This is Real News Media TV, coverage you can trust. Please like, share, subscribe, and hit the notification bell. Select all for daily news updates. Court rules defendants in discontinued suits not always entitled to legal costs. Legal costs will not be awarded to defendants in every case in which claimants have discontinued suits against them, the Court of Appeal has ruled. The court made a ruling when it dismissed an appeal brought by Dr. Conrad Morris against a Supreme Court ruling in favor of former patient Troy Campbell, who had brought a negligent suit because an instrument was left in his abdomen after surgery. Attorney at law Andre Earl, who represented Campbell, said yesterday that a ruling last week was a major victory. This case establishes a precedent as to the circumstances in which a defendant against whom a case has been discontinued ought to be deprived of his cost, Earl said. Earl explained that the case was the first of its kind in Jamaica, and the appellate court had to look at authorities from jurisdictions overseas in coming to its decision. He explained that the normal rule was that a claimant who discontinued a claim was liable to the defendant for costs incurred up to the date of discontinuance. Earl said the court found that there were cogent reasons for departing from the normal principle. Campbell had surgery at the Mapen Hospital on September 24, 2008. It was subsequently discovered that a crural artery forceps was left in his abdominal cavity. A second surgery was done on October 2, 2008 to remove the instrument. In July 2014, Campbell, who was also represented by attorney at law Peter Gay Manderson, brought a negligent suit against the surgical team who were Dr. Morris, Dr. Percival Duke, and operating theater nurse Audia Elliston. The Southern Regional Health Authority and the Attorney General were also named as defendants. Morris, who was represented by Queen's Counsel John Graham, did not accept liability when the suit was filed and stated that he intended to defend the claim. The Court of Appeal referred to the fact that Earl had informed Graham in April 2015 that Campbell was in negotiations with the Attorney General with a view of settling the matter. The claim was settled in June 2015, and Earl informed Graham of the settlement. The court pointed out that after the release, Graham wrote several letters to Earl to find out if a notice of discontinuance was filed. The notice of discontinuance was filed in September 2018, which effectively ended the claim against the parties. The court said over the 2-year period, Morris did not indicate in any of the letters written by Graham that he was desirous of proceeding to trial and had no interest in the settlement. Morris filed a bill of cost for $778,000 in October 2018, which was dismissed by the Supreme Court Judge Evan Brown in February last year. He then filed an appeal. The Court of Appeal, in its ruling, said the judge adopted the proper approach in arriving at her decision. Please remember to like, share, subscribe, and hit the notification bell. Select all for daily news updates.